Tom Shaw from Dallas, Texas, attorney, and Danielle and I want to talk to him about covenant. We just want to hear what you think about the laws and kind of what stance Nashville has taken on it.
Yeah, Sheila, thank you for having me on and interviewing me. Let me start off by saying, as I think I've told you before, my areas of expertise are limited to Texas, but I have looked at the matters in Tennessee relating to the attempts by the parents to access or restrict access to the, I guess it's the journals and other evidence in the Covenant murders. It started out as attempts by folks wanting access to both the journal or journals and the evidence, and it's turned into a big fight. Interestingly, Sheila, one of the fascinating aspects of this is that the parents were assigned the rights to the journal. And I'm not sure that you can assign rights to evidence like that. I think that that's going to be an issue, or if it hasn't, if it isn't an issue now, it might be an issue that someone needs to look at, because I've not seen that before in a case. Now, the other interesting aspect to the case is that while they say they're investigating it, the police are claiming they're investigating it. I don't know what they're investigating at this point, because in order to have an investigation of a crime, there's got to be a criminal. Otherwise, it's not a true investigation. But it appears as if there's some forces at work trying to limit the dissemination and the application of the First Amendment.
Doesn't this create more of a problem than it helps by withholding this evidence? Because now rumors, theories, conspiracies are all being shared versus whatever the evidence is the evidence, and it will stop after it's released.
This is one that I agree with you on, Sheila. The attorneys have made the principal argument, the argument that release of these journals will result in copycat killers. No one's ever been concerned about that before in arguing for the release of materials. It seems to me that that's a peripheral argument, because you're going to have copycats regardless of whether the journal is released. They're not copying the journal, they're copying the act, which has already been highly publicized. And I read the article that they cite as the support in peer-reviewed literature for this argument that publicity causes copycat killers. And that may be true or not true, but you can't avoid publicizing the act because it's news. And publicizing the journal is understanding why the act occurred. And the case that's cited probably is well known to Nashvillians. It involved an elected official who was under investigation for, I think, bribery. or some sort of criminal activity, and he took his own life. And apparently there were some writings that he had left, and as justification for allowing the access by the Open Records Act equivalent in Tennessee, the court said that the writings would assist in determining whether or not this was a suicide or a homicide. And it seems to me the argument could be made in your Nashville case that these writings could help determine whether or not the person who committed this crime was sane or insane at the time that they committed the crime, which is in the public interest to know if you have a crazy person or a person who is committed to committing a crime.
Well, I was going to say, I know we keep speaking of journals, but specifically as they're referring to it in the media as her manifesto, which to me is, it's not a diary, it's not a journal, it's an intentive note of why she did what she did. So what's in that manifesto that they want to hide? You know, that's, I think, where it falls with me.
Well, I don't know, obviously, what the manifesto says, but we know in history manifestos are grist for the press. For example, Kaczynski had a manifesto that was readily available to the public. Other manifestos that my general recollection that have been accessible to the public are ones involving the guy in Columbine, as well as I think the shooter in El Paso had a manifesto. And it seems to me that at times the press is selective in which manifestos it wants to publish and which it wants to keep secret, and that's reflected by what the government wants.
In a case is closed, it is open to the public to get the records. I don't understand why this is even a conversation. The case is closed. The suspect.
You don't know that, Sheila. You
Suspect's
don't
dead.
know that the case. But the whole point of what the law enforcement may be doing is keeping it open in order to avoid having to disclose it. So I don't know what the procedures are for closing a case. I'm not sure we know that yet, that the case is closed, because they could argue that they're still looking for people that participated in this with the shooter, that there may be others. This may be a wider conspiracy, and they'll keep it open for a long time.
In my cases, a lot of times that is a ploy that police use so the family cannot get documents.
That's right.
Or recordings. And
we've seen that before.
Personally, yes. And what I'm concerned with in this whole conversation is that it will further harm the victims' families that I work with, that it's gamesmanship as far as picking and choosing what the public can see.
To me, the more chilling argument is it keeps from the public information that the public has an absolute right to access, and members of that public happen to be your victims. It may affect much more directly than general members of the public. That doesn't make it less compelling to produce.
Right. Well, yeah, I think this is showing that Nashville is becoming less and less transparent with the public.
If, in fact, the Nashville Police Department don't disclose it, I think that speaks for itself.
One of the things I want to say about the copycat theory or conspiracy that could happen, I think Nashville police took that off the table the moment that they released the police going in. I think that was a brilliant move, and that was it's if anybody thinks they're going to go into Nashville and not be taken care of by the police, they're wrong. The police put that out there.
I think you're right. And in today's environment, we have members of the public that are troubled people, and they want publicity. It doesn't have anything to do, it seems to me, at times, with whether or not it's a copycat. It's simply disturbed individuals that may be seeking infamy or attention in life or death. They're arguing that there's also no compelling interest in disclosure.
Isn't disclosing public interest in general?
More information the public has, the better citizens you create, because fully informed citizens make better democratic decisions.
Well, one of the arguments is about the autopsy photos and the picture. Argument is they don't want autopsy photos or photos of the crime scene with small children. Absolutely nobody wants that. But there's already a law in place in Nashville, in Tennessee, that that's not allowed. So I think that's a little bit misinformation that could be given to the public. It's already a law that it cannot be given to the public.
That's what they call a straw man argument, because they know that that's already off limits, but they use that as an argument to preclude other things from being disclosed. You're right. No one has any argument that images of little children murdered or having an autopsy done on them is of no interest to the general public. But they're using that to make their point when that's not necessary, because it's not something that's disclosed anyway, already pursuant to state law.
Tom, what happens if the judge in this case right now shuts down the release of this information?
I suspect that everyone will agree to an expedited hearing in the Court of Appeals. Now, I don't know the procedure for expedited appeals, but I think that the trial court judge herself said that she saw that it was going to be highly likely that this would go all the way up to the Tennessee Supreme Court. And because of the nature of the information sought, it seems to me that it's in everyone's best interest for this to be fast-tracked to the Tennessee Supreme Court and have it argued fairly quickly.
Again, I go to my argument. This is making it worse by not just releasing it and getting it over with. I think it just is ripe for rumors and conspiracies, and the law is the law. The law is to release it.
Right. I think you're right on that, and they're trying to make excuses to avoid complying with the First Amendment.